DUNCKELMAN versus DUNCKELMAN. Okay, you may proceed.
May it please the Court, I'm Leonard Ross here on behalf of the appellant. Your Honors, there are 5 separate arguments at issue in this particular case. The first argument concerns the fact that we submit that the trial judge erred in awarding the wife the vast majority of the marital assets as lump sum alimony. And what the Court did was, on the basis of equitable distribution, first divided the house 50-50. Then on top of that, awarded the wife 30% of the house, which was the asset that parties had, the major asset. They had some others, but the major asset the parties had. In addition to that, the trial court then said, I'm giving the wife all of the household furnishings and belongings. Now, lump sum alimony can be awarded based on 2 major principles. One is traditional alimony principles, need and ability to pay, and the other based on equitable distribution, to make up for the difference in equitable distribution. The problem we have here, based on the first allowance for lump sum alimony, traditional alimony principles, need and ability to pay. So we had an 83-year-old husband, 84 at the time the judgment came out, 83 at the time of trial. He is living on $1,000 per month, and that's it, on Social Security. In addition to that, he is extremely ill. The difficulty is that there was an abundance of testimony with respect to his illness and his need to live in an ACLF. Unfortunately, on his $1,000 a month, that could not even meet the needs for medication. He was living with his daughter at the time. The daughter said she can't give him any more money. She's been loaning him money just to get medical care. She's out of money to do so. He couldn't even meet his needs. He couldn't go into the ACLF. What would happen is he'd be out of money. So based on the principles of need and ability to pay, there was absolutely no ability to pay on the part of the husband. What this judgment actually did was endangered the husband's economic status. He's left with less than 20% of the marital estate. No way to survive in any way whatsoever. And as Kanakaris said, he went from prosperity, or maybe not even prosperity, but clearly to misfortune. So with respect to that, we would submit, Your Honors, that was clear error. The second aspect that we've raised is a mortgage referred to as the Collins mortgage. We start with the principle that assets titled jointly are presumed to be marital assets.
What property was that, did that mortgage encumber?
The mortgage was premised originally that the money came out of joint funds, went to a third party for a house that originated. This was the argument at trial, that it came from a Middlesex property. The wife had, in other words, money was loaned.
The wife owned the Middlesex property before
Correct.
they were married, but did it, I thought in reading through the record that it did not come from the Middlesex, and that the trial judge may have just made an error there, that it came from...
Came from the joint account.
Yeah, it came from a joint account, but it encumbered property that belonged to the son, Kevin?
Correct.
All right, what property did he own?
He owned some other property that he had purchased. And so he's just like any other third party. And the reality of the situation is that...
How did you bring that error to the trial judge's attention, that, he may have mixed up the parcels of property that the mortgage encumbered or came from? Or?
Well, we certainly brought it to his attention at the trial. And the reality of the situation is, from the time of the trial to the time of the judgment was about 6 months. So it took a long time. I don't know whether or not the court, dealing with the different mortgages, dealing with what occurred into the the joint account, whether the court confused it or not.
So essentially, a loan was made out of a joint account.
Right.
And the trial court thought that the mortgage encumbered the Middlesex home, but it actually encumbered a home that was owned by Kevin that was not the Middlesex home. Is that essentially correct?
I think what the trial judge said, although it's a little bit unclear, I think what the trial court thought is that the wife had Middlesex property before that.
Right.
She sold it. But in reality, the Middlesex property was deeded into the name of both parties.
Right.
It was deeded into both parties. The wife
and then it was sold to the daughter, wasn't it?
So, correct.
All right. And then the funds from there went into a joint account along with other funds perhaps. And then out of that account, the joint monies owned by these parties, they loaned Kevin some money.
Correct.
And did he gave them a mortgage back on a parcel of property that was not the Middlesex property, right?
Correct, Your Honor.
All right, I just want to make sure I understand that.
That mortgage was given in joint names.
Correct.
Parties here.
Right.
Payable to both parties, and the checks went to both parties. And the Middlesex property, even if you look at the Middlesex property that the court thought was relevant, that Middlesex property was placed into both parties' names as well. The husband and the wife.
After the marriage, sure.
Correct. And the wife put it in both names, and the wife, being a real estate agent, she actually handled the transactions and recorded the deed as well. So we certainly have significant problems with respect to that. It was a marital asset. Otherwise, you'd have to turn around and start saying, wait a second, let's look at the husband's Social Security payments that went into the joint account. Let's separate that out. You couldn't do it. It was clearly a marital asset. The next problem we have is with respect to values. The court went ahead and, as I said, gave the house to the wife another 30% and all of the furnishings and all of the belongings in the marital house to the wife, including a van. Now, the problem is in the judgment, there is no value as to the van. There is no value as to any of the other properties. And at trial, as you'll see from the transcripts, a video was shown, details were put forth with respect to each and every item of property. Hundreds of tools were in the home that belonged to the husband that he testified to. China was in the home, cabinets, furnishings, but everything just went over to the wife's side. And we believe this is error, particularly error, if you're going to turn around and you're going to say, the wife is entitled to lump sum alimony because she won't have enough assets. Well, you need to look and say, what's she getting? And no value being put on that, that's problematic.
But what evidence or testimony was put before the trial judge as to the value of all those assets?
Your Honor, testimony was put forth with respect to the van's value specifically. And while it's $4,500 or thereabouts, that's still a significant asset when you look at, these parties are living on, the husband has $1,000 coming in, can't meet his expenses. $4,500 is a great deal of money. In addition to that, the financial affidavits had values on there. They specifically had values. One of them had $10,000 listed for furnishings. Another one had $30,000 listed for furnishings. So the values were there for the court to look at and make a determination. The other argument that I had raised concerns the financial affidavits. The wife submitted a financial affidavit, an amended financial affidavit, 1 day before trial. The original financial affidavits, and it's relevant with respect to the value of the house, the original financial affidavits were, both parties were in agreement. House is worth $750,000. 1 day before trial, there's a new one. And the new one has nothing in there with respect to value. The wife then was able to testify, there's nothing in there because the value has changed, and she goes forward with respect to that. The husband is prepared to argue that both parties have agreed to $750,000. And this is relevant based on, once again, the argument to say, well, not only are we prepared to argue that, but there's certainly no need for alimony if they're going to be dividing a $750,000 asset as opposed to the asset that's worth somewhere in the neighborhood of $500,000, as the wife explained. Under the rule, which is 12.285E, there is continuing duty to supplement the financial affidavits. and the court should make an inquiry. Why was this not done? Why are you giving this to us at the last second? The Chief Judge's rule, which is 2006-04, speaks of, and that's Judge Parsons' rule when he was Chief Judge, that speaks of the fact that 10 days before a hearing, that should be provided. And we submit that in this particular case, it clearly prejudiced the husband's argument, as we were prepared to say both parties have sworn $750,000.
Well, the house was eventually valued at $500,000 based on some testimony and a report that was issued that was generated from the internet, right?
Yes.
All right. Well, what's the problem with the trial court relying on that as to determine it was $500,000?
And that is the last argument on appeal, Your Honor, which I think is an interesting legal argument at the very least, and that is that the court relied upon a Zillow.com estimate. And the Zillow.com estimate in this particular case, we would submit, is clear hearsay and should not have been introduced into evidence. Zillow.com is
Was she permitted to testify about what it said?
I think not what it said. She's permitted an owner.
Without objection, by the way, right?
An owner is permitted to testify to.
Well, but I mean, she testified not only what her opinion was as to value, she testified that she got it off of this website, right?
And she's certainly
objection, right?
Yes, Your Honor. She's certainly permitted to say this is the basis of my information because I'm I'm in real estate, and an owner is permitted to say what their basis is.
Then, if she's permitted to do that without objection, what difference does it make whether the trial judge accepted the report and evidence or not?
Well, I think when you have a report in there, which is.
She testified to the value from the report without objection, and the trial judge heard that. So what difference does it make? If there was error, wouldn't it at least be harmless?
I don't believe so.
Why not?
I think the difference between an individual saying, okay, I've read some things, and I believe the basis for my opinion, because an owner is permitted to testify as to what their belief is based on their opinion of their own value. I've read some things, and I believe the value is $500,000.
But as Judge Torpy just asked you, she was permitted to testify from the report without objection.
But having the
so how does that? So if the trial judge subsequently admits the report, what difference does it make? Because
the report is like having another expert there. There's a great difference.
Why would that be harmless error?
Because you give much more credence to the actual appraisal report than you would from an owner. Owners go in there and they say all the time, okay, I've read this, I've read that, and the basis for my opinion is, I think my house is worth X number of dollars. I think my car is worth X number of dollars. You're permitted to do that under law, and there's certainly a reason for that. There's a basis. But this is equivalent to having an appraiser come in and testify. And to have an appraiser come in to testify and say, and that's why it's not harmless.
I think you're right that a hearsay objection should have been sustained, but I think the evidence was cumulative. And here you got to show us it's a bench trial. You got to show us. The burden is to show harmful error. When you got cumulative evidence and the trial judge sorted through it, I'm not sure you're going to find an appellate court case that reverses a trial judge on essentially cumulative evidence in a non-jury setting. I don't think we'll find a case like that.
And Your Honor, I understand your belief with respect to the cumulative evidence, but I would submit that the difference there is that if a court says, okay, I listened to an owner, and an owner is allowed to testify as to what they believe they're
But she went beyond that which she's permitted to testify. You can give an opinion on value. You can't publish hearsay under the guise of an opinion. You can't say, okay, well, I think the value is $100,000, and my basis for that is the appraisal that I read last night. That's not when you let that in, that's something I think should be objected to.
Well, I understand, Your Honor. I do understand that. But I do think it's different as a trial judge when you sit there and you say, okay, I've heard the owner testify wherever she got her information from. But when I see this separate appraisal, and this is clear hearsay, I think, and we do have these problems in trials all the time now in the state of Florida. What can you use? What can't you use? And I think you cannot use this without some sort of foundation, number one, or two, having the the expert come in. I'll reserve time if I can, Your Honor.
Okay,
Thank
5
you.
minutes and 33 seconds left.
Morning, judges.
Morning.
Richard D'Amico, Daytona Beach, Florida, representing the appellee Patricia DUNCKELMAN. I mean, at the outset, before I get into the actual rebuttal here, this was a difficult case from the trial judge's standpoint. You're dealing with two very elderly people, and the judge did spend quite a bit of time thinking this thing out. And as one of your cases,
Do you agree, getting to the Collins mortgage, that the proceeds came from a joint account that were paid to the son named Kevin, and that the mortgage was placed on a property other than the Middlesex property?
you know, we were trying to find that in the record. I didn't believe it was against another property, but no matter what, the proceeds did come originally from the Middlesex house, and that's what the judge's reason was.
Well, that may be, but it went into a joint account, and we don't know, whether that joint account, whether those funds were fixed in that account, other funds commingled, but it went into a joint account. From that joint account came a loan to Kevin, and the mortgage was placed on a property other than the Middlesex home, right?
Right. Well, the judge did trace that back, though, and said that essentially that Middlesex home was property that
Why
the
doesn't
husband...
that? Go ahead.
Property that the husband had always said was going to be her security, and that those funds were earmarked, were actually taken from the one fund and just changed their identity, really, is the way we look at it. But let me just get into that for a second. What the problem was in the case was that you're dealing with people that have no income. The husband has $1,000 a month income. The wife has $475 a month income. That was what the problem was with the case. The only other income was this Collins mortgage, which is $524. So you're talking about one person's $84, one person's $77. They have $2,000 a month total to live on. What the judge did, and we're talking about an abuse of discretion standard, he said, if I give the Collins mortgage to the wife, she gets $524 plus her $475, that's $1,000. The husband has $1,000. He basically equalized their incomes at this age, and both of them had medical problems.
But the trial court essentially ruled that the Collins mortgage was not a marital asset, right? I mean, that was something that she owned prior to the marriage, and that.
Well, yeah, but what the court, what I think,
is that a mistake or not?
Okay, well, no, I don't think it's a mistake, because the court had the right under Section 61.075 to make different contributions of those non-marital assets. It says that the court could consider the contribution of each spouse to the acquisition, enhancement, and production of income from non-marital assets. Okay? So what happened in this case, and in the
Your argument
brief,
is that it all equals out anyway, so it doesn't make any difference whether the trial judge made an error in determining what was marital or non-marital. Is that essentially what
that's what that seems to be what his reasoning was, because what he could have done is said, okay.
I think the trial judge thought that it came from the Middlesex home, that she owned it before, and that that was a non-marital asset, and despite the fact that the proceeds went into a joint account anyway. I'm not so sure I buy that. But.
Even if that's correct, and we split the Collins mortgage, then he would have had to award the wife some alimony, because she would have been at $800 and he would have been at $1,300. You have a 27-year marriage here. And so the judge was looking to have some survival. We're in a real estate market now where we're talking about this home that they own. We don't know when this thing is going to sell or how much it's going to sell for. That asset could be on the market for years the way things are going. So right now the judge was concerned with, how am I going to ensure some survival for these people?
But if that's what he wanted to do, he clearly could have done that. He could have worded it that way.
Well, but it ended up being pretty much the same thing is what we're saying. I mean, because he would have the right to have an unequal equitable distribution. If you look at page 5 of our brief, I think it's page 5, we listed the wife contributed virtually $326,000, and that doesn't include one of the houses that the value was not in the record of non-marital assets to the marriage. The husband only contributed something like $80,000, and under 61.075, the court has the right to make a disproportionate equitable distribution to compensate for that, and he even said it in his judgment. In the second to last page, the judge says that the court finds this is a long-term marriage, and that the wife's financial contribution toward the purchase of the marital home, based upon the sale and mortgages issued on property she owned prior to the marriage and inheritance proceeds, and sustenance of the marriage merit that she receive some form of lump sum alimony. Now, he said lump sum alimony, but what he's really doing is awarding her a disproportionate equitable distribution. He may have used some different terminology, but the fact is that the judge, he had the right to do equity among the parties and do equity as to these assets. Now, the wife, if it hadn't been for the wife's contribution, I mean, this is an extraordinary contribution, there wouldn't have been a house that's free and clear sitting there in Palm Coast. So, essentially, what we're talking about is how do we juggle this $2,000 total income? And I think the judge basically split it in half. It's true, it could have been, I mean, he could have given half the Collins mortgage and ordered alimony. I think the Collins mortgage is something that ends at some point in time, so he wanted to ensure that the husband had that $1,000 a month coming in. And he ensured that by this judgment. And again, we're dealing with an abuse of discretion standard, which is very broad. I mean, how can you criticize him for helping this woman who has $475 a month coming in and bumping her up to $1,000? I mean, that's basically what he did. I mean, would you want to leave the wife with $475 coming in and the husband having, $1,500 coming in? That wouldn't be right on a 27-year marriage where the wife has contributed $325,000 plus worth of marital assets. So the judge was well within the bounds that are under 61.075 to give the wife a little bit more, which he did. And I don't. I think I can see his reasoning, and the standard is, whether no reasonable man would have done this kind of a distribution. When you're dealing with this little income, what else could he have done, really? There were some other issues that were brought up, and I think that we pretty much covered them in our brief. The issue of the personal property, there's some case law that we had cited that says that the court doesn't have to go through each and every toaster and item of personal property, and that if they had a problem with it, that they should have made a motion for rehearing. We cited the Simmons case on that. And on the financial affidavits and the valuation, this Zillow report, I do agree with some of the things the court said, but there's an exception to the hearsay rule that this was admitted under, and it was 90.803 subdivision 17. That was the same section that the husband's counsel used to get in a report on a vehicle value. So, the court said that he thought this was reliable, that this report had been used by other experts, and in another case that he had. And the actual rule says that the market quotations, tabulations, list directories, or other published compilations generally used and relied upon by the public, if in the opinion of the court the sources and method were such to justify their admission. So the court admitted that Zillow report. But in reality, what difference does it make? I mean, whatever this house is worth, and it's probably worth a heck of a lot less than the $500,000 at this point in time, it's been ordered to be sold, which nobody's really objected to. How long is it doesn't matter what this value is. What matters is what a buyer is going to pay. And when that happens, then there'll be some money that'll come out. It may be today, it may be 2 years from now, maybe 3 years from now. But at this point, the parties are living on $2,000 total in income. And I think the judge was eminently correct in giving $1,000 of it to the wife and $1,000 of it to the husband. And as far as giving her a greater, a little bit of a bump, basically what he did was, he gave her a little bit of a reward for some of her equity that she had contributed to the marriage, and it was a very, very large amount of equity. So on balance, using the Conackra standards, the judgment of the court should be affirmed. I don't know if there are any other questions. Thank you.
Thank you. 5 minutes and 33 seconds.
Thank you, Anna.
Well, wait a minute. All right, I hit the wrong button, but 5 minutes and 33 seconds ago.
Thank you. The principle that we all know of is you don't equalize incomes. You just don't do that. So the fact of the matter is, if the wife is living on an income that she can't survive on and the husband is living on an income that he can't survive on, you don't equalize the two. In this particular case, the husband was living on $1,000 a month. If under Mr. D'Amico's argument you said, okay, give her as lump sum alimony the Collins mortgage to equalize incomes, that still wouldn't warrant giving her another 30% of the entire value of the house and all of the household furnishings in addition to the van. That just doesn't make sense. It doesn't make sense even to give her the Collins mortgage if you want to equalize incomes, because you can't equalize incomes, number one, and number two, that was marital property. And he found it to be non-marital property. It just didn't make sense.
Did you file a motion for rehearing?
No, Your Honor.
Pardon?
No, Your Honor.
Are you able now to complain that there may not be appropriate findings as to valuations in the final judgment if you didn't file a motion for rehearing and bring that to the trial court's attention?
I believe so.
You believe you can?
Yes. Right. The last problem.
Isn't there a case law that essentially says that if you don't do that, then you either waive it or it's the trial judge? Essentially, it's a waiver argument. The trial judge didn't have an opportunity to correct it and go back and amend the final judgment to include the values.
I understand that argument in the opposing counsel's brief.
Why isn't that appropriate? Why isn't that the correct argument here?
Because I think that in this particular case, there were no values put in, and the court turned around and awarded them all. It's not a problem. It's just that there's, that you can't look at the value and say, okay, we got to divide.
You're familiar with the Simmons case. I mean, yes. It was cited in the briefs. Isn't that exactly what the Simmons case says?
Well, in this particular case, I think it's a little bit different. And the reason it's a little bit different is that in this case, the court just turned around and gave everything to the wife. So it's not only the fact that the valuation is difficult to say, how do we split that up 50-50? It's clear error when the court just turned around and gave her everything. And that's why I believe it's distinguishable. The last issue, if I have the time, is that Mr. D'Amico brought up that it's not relevant because the house is going to be sold. But it is relevant as to what the value is that the court came up with. It is relevant because if the court was saying, is there enough money for the wife, and therefore I need to give her a lump sum alimony, if the court looked at it and said it was worth $750,000 versus $500,000, that would be relevant because it might make a trial judge say, well, she's getting half of $750,000. She does not have a need for an additional sum of money.
I thought Mr. D'Amico said it wasn't a need or ability analysis. It was a lump sum alimony for equitable distribution. Didn't he just say that?
I believe that was what his argument was. But there's two methods of doing so, obviously based on need and ability, and the other is based on equitable distribution. The court found no special equity. The court, specifically said there was no special equity. So it just doesn't make sense.
But would you agree there was some evidence or testimony presented below from which a reasonable judge could find that the wife contributed extraordinarily to the marriage?
No, I don't believe so. And the reason I don't believe so is that you have a marriage in which both of the parties testified that they had worked together, bought and sold properties, worked together as a team and did that. In addition, the husband put money in from his business. He put money in from a non-marital house into the joint account. The wife turned around and actually deeded any of her non-marital property into the husband's name at first, so it became marital. Then it went into the joint account. Then Social Security payments from the husband went into this joint account as well. Everything is commingled together. And you cannot separate it out and say, wait a second, I gave this money, I gave that money. Couldn't do it in this case. It was that they worked as a team. And no, I don't believe there was adequate evidence to do so.
But not only did she out-contribute him by almost 8-1, but didn't she also provide round-the-clock care for him and things like that? And
the case law that I cited in the brief is that when you have someone...
The judge made mention of that, too, in the record, didn't he?
Certainly. And when we're together as spouses, when you're living together as spouses and you're getting older, it's expected that one party is going to help the other one. I'm not going to get more credit for taking my wife to the doctor as she gets, to be in her 80s, nor is she going to get more credit or should. And under the case law that I cited, you shouldn't. That's expected of a spouse, for better or worse.
Okay, 5 minutes and 33 seconds.
Thank you, Your Honor.
Thank you. All right. Thank you both very much. Yeah.